Thank you. Now, as I indicated, the case is set for 20 minutes aside. Mr. Stafford, would you like any rebuttal time?
I would like to reserve 4 minutes, please.
And are you, Mr. Stafford, are you ready to proceed with your argument?
I am.
Are we ready to hear it? Thank you so much. You may proceed.
Thank you. Dr. Myers is a physician. He practiced as a general surgeon in rural Kansas. Several years ago, he began experiencing some emotional difficulties, and at one point they reached a crisis level in his life. That difficulty, the emotional difficulty, can be summarized as an inability to navigate personal relationships. And in our brief, at pages 2 through 8, we detail those emotional difficulties. And I am guessing that the judges have all read the briefs at this point.
You're correct. We read your briefs and we've had a pre-hearing memo prepared for us.
Thank you. So as a result, I'm not going to go through all of those difficulties. They are rather personal in nature, and I understand that this is live streaming. Dr. Myers did act out during those difficult times. He stalked an ex-girlfriend. Ultimately, in June of 2013, he surrendered his license to practice medicine and surgery, and he seeks reinstatement of his medical license. I understand that there is a legal issue that we need to address, and that is the jurisdiction to hear this appeal. And I'd like to begin there. On judicial review, the district court upheld the board's decision, affirmed the board's final order that denied reinstatement. We filed electronically a notice of appeal, and that notice was timely. Unfortunately, that 2-page notice did not have page numbers on it. And the district court clerk then rejected the filing. So when the notice was filed, and I take personal responsibility for the difficulty here, but when it was filed, I did not really appreciate, I guess, the technical aspects of e-filing. I saw that we got the message that the notice was filed. And it never dawned on me that it might be rejected. It was a simple giving notice of about one sentence and a signature and a certificate of service. But it was rejected. I'm not shifting the blame, but I believe the policy is stated in Supreme Court Rule 23C. I come to find out that that Supreme Court rule does not apply because Shawnee County District Court had not yet adopted the same e-filing system. And I'm not sure how one would know that. That's a fairly technical question.
And you were show cause by our court concerning Rule 23C1. And basically our court was saying that would not apply here, as to make your notice timely, okay? Right. But you did make an argument that 23C1 it was timely. And at this stage, we are considering whether or not 23C1 would trump the district court local rule. And if you have an argument that you want to make now about that, we welcome that right now.
Yes, thank you. And that's exactly where I'm going, is that whether or not the rule specifically applied to the Shawnee County District Court, at least the policy has been adopted by the court that appeals are not cut off by a technical defect. unless it rises to the level of one of those issues that 23C would apply to. And then we have to look at the district court rules. I researched the district court rules after the fact and do not find a district court rule that says page numbers are required. I found the district court rule 3.119 that refers to an administrative order 2018-101, and neither of those items require page numbers. Research would also direct you to Supreme Court Administrative Order 268, and that does not require page numbers. There are guidelines that are plainly written, not technical language, but more plainly written, that eventually found on the court's website. But they're guidelines, they're not a rule. I don't believe that a rule existed that would allow for this filing to be rejected. And again, I'm not trying to shift blame or avoid my own responsibility, but rather to note that I don't believe this filing should have been rejected because I should have known. I recognize.
And you back this argument up with another argument relying on Becker versus Montgomery. Do you want to touch on that for us?
In that case, Justice Ginsburg wrote that a lack of a handwritten or a wet signature on a notice was not fatal. It was an imperfection, but it was not fatal because there was no genuine doubt as to who was appealing, from what judgment, and to which court. And I believe that that same philosophy applies here. There could be no real doubt that we were appealing to the Court of Appeals. There is the Lambert case that is as similar to this case as we could find. It involved a flawed filing on the last day before the statute, or last day of the statute of limitation period. And in that case, there was a cured filing. And the court did not resolve the issue of whether it should relate back, because in that case, unlike in this one, the documents were not filed with the court to show that it was really the same document that had been filed the second time as the first. In this case, we did what we could to overcome that kind of lack of evidence and show that it's the same document that was filed the second time. It just now has page 1 and page 2 added to it. We found out that the document had been rejected when we went to gather the items necessary to docket this appeal, and immediately researched what had happened. And I don't know if you're familiar with Microsoft 360 email, but you've got, of course, the spam filter, the junk filter, and so on. There's also a focused inbox and an other inbox. In the staff member who had filed this, in her inbox, the rejection had gone to the other inbox and not the focused inbox. Otherwise, I think she would have caught it. I'm sure she would have caught it. Again, not trying to make excuses, but to explain exactly what happened here, that this was not a matter of just ignoring what was going on, but maybe it was the perfect train wreck at the time.
Let me ask you a question, Mr. Stafford. When we're looking at a statute of limitations, that that is not the same issue as here, where a notice of appeal vests us with jurisdiction. In a statute of limitations, we have some ability to look at equity and apply the doctrine of equitable circumstances or special circumstances to excuse something like this, if in fact there is no local rule and the clerk made an error in rejecting it. Is your argument essentially that your notice of appeal said everything it needed to vest this court with jurisdiction?
Yes, it is. And that's in line also with the Honeycutt decision that explained that pleadings are to be given liberal construction, and even in jurisdictional matters are to be given liberal construction. Yes, I believe that the initial filing that gave notice of the appeal vested this court with jurisdiction. Excuse me. I'd like to move to the merits of the appeal, and I'm not sure exactly how much time we have left here.
But you have a good 6 minutes, 7 minutes, because you dealt with a jurisdiction. I'm going to let you have, before you use your rebuttal time, let's say that you have 10 minutes because we dealt with the jurisdiction issue here. You have 10 minutes to deal with the merits before you get into your rebuttal. You understand that?
Yes, I do, and thank you. There's a legal standard for a person seeking reinstatement of a license. Now, Dr. Myers surrendered his license, and for all purposes, that is treated as a revocation. There's no dispute as to the effect of surrendering his license at the time. The legal standard appears at 65-2844. It requires that the applicant show by clear and convincing evidence that the person is rehabilitated sufficiently to warrant the public trust. In applying that statute, typically the board has relied upon what we call the Vacus factors. The John Vacus versus the Board of Healing Arts, I believe is the name of the case, in which he sought rehabilitation from a revoked license. Those factors are guidelines for the board. They're things that the board may consider. It's not a mathematical formula. It's not a checklist of all the things a person has to meet, but it's a way to understand what it means to be rehabilitated.
Is the fundamental test then a totality of the circumstances with some guidance from the VACA factors as things that ought to be looked at generally? Is that what you're saying?
Yes, exactly.
Okay.
Thank you. So in determining whether Dr. Myers is sufficiently rehabilitated, in determining whether those Vacus factors are adequately discussed, I think there's one important document in that whole entire agency record, and that's the hearing transcript. The hearing transcript is very telling. It shows a human side of Dr. Myers. It shows the dark side in his life in the past. Through the testimony of the witnesses, you can see his initial but incomplete attempts at self-understanding. And then, don't know what precipitated this, he had the aha moment. He truly turned the corner toward self-improvement. He learned how to engage in valuable and respectful relationships. And he has given back to the community. Early on in the proceeding, it became fairly clear that the presiding officer, the hearing officer at the time, was not very happy with Dr. Myers. It was a little subtle as to what was going on, but it appears to involve her own personal experiences and her own emotions. I don't want to get into those in detail in a public forum, but they are briefed at page 35 of our brief. And I think that set the backdrop for how she filtered all of the information that came to her. Her animus towards Dr. Myers is reflected in her determination on witnesses' credibility. As stated in the initial order, all of his witnesses weren't credible. I understand, and the Administrative Procedure Act is very clear in this regard, that due regard should be given to witness credibility. But due regard doesn't mean absolute adoption of those findings of credibility. Again, reading the transcript, I think you'll see that these witnesses were very credible. Dr. Kathleen Keenan, for example, a psychologist who treated Dr. Myers. She has worked with the assessment centers here in Kansas. She has worked with the Missouri Physician Health Program. She works with professionals, so she understands where professionals, where they are in their mind and their heart. And she recognized the difficulties he was having. She's the one who said, at first, I didn't see much hope for him. And she even related that to Dr. Hale, another treater. But suddenly he turned the corner. This is in her testimony. He turned the corner and he rolled up his sleeves and he began to work hard on himself and figure out what was going on. And she also was very honest. She said, he's going to have to continue working. But for now, he is sufficiently rehabilitated. So it was rather amazing that Dr. Keenan's testimony was deemed unpersuasive and lacked credibility as being dismissive. So Dr. Myers presented several witnesses who testified as to where he had been, where he is now, what he has done to get to where he has now. Yes.
Let me ask a
Yes.
question that it goes to something practical that I'm not sure what the answer is. He's a surgeon by practice, correct?
Yes.
And I presume if his license were restored, he would continue as a surgeon. He certainly would be eligible to.
Yes.
And if I'm reading the record correctly, he has not been in a surgical suite since 2013, at the most recent. May have been longer than that, but I mean, it's somewhere in that vicinity, right?
That is correct. We did offer.
Well, let me.
Go ahead.
My concern, I guess, a little bit, and the board sort of fences around with this, is someone of his age who has not been in a surgical suite in 7 years. Is there a way to determine that he has the physical capacity? I'm not talking about the mental capacity. I mean, literally the physical capacity at this point to perform adequately as a surgeon.
The answer is yes. And gosh, as a potential patient, I wouldn't want somebody coming in to operate on me if they haven't done anything like this for several years.
So how do we determine that? I mean, there's nothing really in the, I mean, you have his testimony that he worked in the garden and that was
right.
discounted. And that seems somewhat imprecise to me as a layperson. I mean, right. What assurance do we have that, you know, again, he hasn't gotten chronic arthritis or his skills haven't deteriorated to the point that he might be a risk to patients from a technical standpoint?
And this answer may be a little bit a long way around the barn to get there, but I'll do what I can. On review of the initial order before the full board, we offered evidence that did not exist at the time of the initial hearing, showing the classes that he had taken, but the board chose not to admit those exhibits.
Well, I understand but, and again, I should let you finish your answer, I guess, before I cut you off, but I'm a judge. So those were classroom, I mean, he's sitting there like a continuing legal education thing. Those aren't physical skill courses, are they?
And it's been a while since I've looked at the exact courses, but the answer is those courses are not all just didactic learning. He has taken courses that require, I believe they were fetal pigs. There was technical skills as part of the course there, the robotics and so on, those kinds of things he has been training on. Now, there's no question that he probably would need some kind of mentoring or supervision if given a license, if for nothing more than to give the public assurance that he is competent.
Well, would we have the authority to remand for that limited purpose?
Yes.
I mean, it sounds like there are established ways to determine if somebody who hasn't operated in a while is capable of doing that. And it's I presume, a relatively objective way of doing that. Do we have the authority to remand with directions that be done?
That is precisely what we ask that you do. And I believe you have the authority to do so.
Mr. Stafford,
Yes.
you have 2 minutes before you get into your rebuttal.
Okay. The board's evidence in opposition to Dr. Myers' application for reinstatement was limited to testimony of people who knew him in the past. The people who did the earlier assessments, they had no contact with him. They had no further information about him as to what he had done for rehabilitation. So living in the past does not go to his present ability, his present professionalism or morality, I guess is a way to say it. They were living in the past and they were uninformed. And I think that's pretty clear in our brief also that, and certainly on the record in the transcript, they were uninformed as to what standards should have been applied to Dr. Myers. An example is Dr. Capo, who is a psychologist, believed that a physician should not date a prior patient for 2-year period. And because of that, because Dr. Myers did have a date with a prior patient, he was unfit. And that standard applies to psychologists. It comes from a regulation. It doesn't apply to physicians. But that's what Dr. Capo had applied to Dr. Myers in order to be so critical of him. Another example is Dr. Capo thought that it was unprofessional for Dr. Myers to do well-woman exams on 2 nurses. He did them appropriately. He did them in the normal course of business. They were scheduled as patients. But Dr. Capo didn't know that. He
Excuse
said,
me, Mr. Stafford, getting into your rebuttal. Do you want to end now so you can retain your rebuttal time of 4 minutes?
Thank you. I will wrap up. The point being, the standards were not appropriately applied to Dr. Myers, and we would ask that the case be remanded to the court. Thank you.
Thank you. Mr. Poling?
May it please the court. This court lacks jurisdiction because although appellant attempted to file a notice of appeal, he failed to do so, and he missed the jurisdictional deadline by more than a month. Under the Shawnee County District Court rules, a document is not deemed filed until it is both received by the clerk of the court and accepted into the court's file by the clerk of the court. That didn't happen in this case.
Was it reasonable for the clerk's office to reject it because it didn't have page numbers on it?
Your Honor, yes.
Why? What's reasonable about that? That strikes me as like really asinine, to be honest.
Well, Your Honor,
why should that be? Why is that correct?
Your Honor, there's a district court rule that applies, and the appellant was immediately notified of the district court rule that he violated. In the Exhibit A that appellant submitted to this court in response to the show cause order, you can see the note from the clerk of the court that tells appellant District Court Rule 3.109 states that every page must be page numbered, including any attachment. So in contrast to what Mr. Stafford asserted, there is a district court rule that applies and requires the page number to be present. And that's—
Well, shouldn't the clerk have conditionally accepted it because it is a jurisdictional document and advised that it doesn't comply and offered an opportunity to correct it?
Your Honor, the clerk did offer an opportunity to correct it. The clerk immediately emailed back and clearly said the district court rule requires page numbers, and here's what you need to do to fix it. So there's a district court rule, and
I don't know how much time was left on the time to file a notice, but what if it were the last day? I mean, it was electronically filed, after 5 o'clock, which some lawyers put things off to the last minute. Why shouldn't the rule be and the practice be that it's conditionally accepted? And if it's non-conforming in a way like missing page numbers, that a corrected substitute be allowed?
Your Honor, if you are the district court clerk, we believe it's reasonable for you to apply the district court rules. And we understand the result of that could be harsh in some cases. There's a couple cases that I wanted to direct the court's attention to that are not in my brief, because I do agree there is no Kansas case directly on point on this issue. But if you look outside of Kansas, the Second District Court of Appeals in Franklin v. McHugh, 804 F. 3rd 627, a 2015 Second Circuit Court of Appeals case, dealt with a very similar issue. In that case, the court dealt with an attorney who, similar to what Mr. Stafford said, asserted just that he did not appreciate the technical aspects of electronic filing in the federal ECF system. And the attorney submitted the filing, the notice of appeal, went through what he believed was the entire process, even got a receipt for the payment of that filing and had that receipt that was appropriately dated, but he didn't complete the last step that was required by local rule. And so he missed the deadline because it was on the last day. And what the Second District Court of Appeals said is that, quote, although Franklin's counsel undoubtedly intended to file a notice of appeal electronically on the last day, his efforts fell short of the mark. Counsel simply overlooked the last step of the electronic process. The court went on to say, quote, we certainly recognize that the implementation and updating from time to time of new multi-layer electronic filing systems, ones that may vary from court system to court system, will present challenges for counsel, especially at the early phases of their use. but counsel have long been charged with becoming familiar and complying with the various local rules of our courts. We thus conclude that a notice of appeal is not filed for the purpose of 28 USC 2107, which is very similar in content to the Kansas statute, and Federal Rule of Appellate Procedure 4 until counsel completes the electronic filing process in compliance with the applicable local district court rules. Now, I've searched, the various courts outside of Kansas. The Fifth Circuit has adopted the same rule in Sudduth v. Texas Health and Human Services, 830 F. 3rd 175. Very similar factual situation to the Franklin v. McHugh case. Adopted the same rule for that circuit, that a notice of appeal was not filed until appellant's counsel has completed the electronic filing process in compliance with the applicable local district court rules. And I do note that although there is no published 10th Circuit cases on this, there is an unpublished 10th Circuit case, Klein v. Olson, 728 Fed Appendix 846 from 2018, in which the 10th Circuit followed those rules. Again,
In
that's
those,
an unpublished.
I'm not familiar with those cases because they weren't in your brief, but in those cases, was there a document captioned notice of appeal that was actually received electronically by the clerk's offices, or did the failure to complete the process prevent a document from being delivered electronically to the clerk's office?
Your Honor, I don't know the full underlying records of those cases. What I know is what
do the opinions say? You've read the opinions, you're citing them to us. What do the opinions say?
The opinions state that in both those cases, counsel had a receipt showing that a receipt from the clerk showing payment of
That's
the
not
filing.
I understand that. That's not the question I asked. The question I asked was, in those cases, so far as the court was recounting the facts that are material, did the clerk's office actually receive electronically a document that was captioned notice of appeal?
Your Honor, in the court's opinions, it's not explicitly clear whether the court or the clerk received it, or how precisely all of the logistics of the electronic system operated. What the salient point is that what the rule that was adopted is the notice of appeal is not filed until an appellant's counsel has completed the electronic process in compliance with the applicable local district court rule. So let's turn that to this case. Again, we talked about the rule that deals with page numbers. I would argue that's not even the most important rule. That was appropriately applied, just as this court held in response to the show cause order. However, the more important local rules is Shawnee County District Administrative Order 2018-101, which states in relevant part, quote, attorneys using the electronic filing system must follow Kansas Supreme Court Administrative Order 268. So if we look at Kansas Supreme Court Administrative Order number 268, at H3, it states, quote, e-filed documents received by the clerk and subsequently accepted into the court file shall be deemed as filed as of the time of the transmission. Again, that didn't happen in this case. It was not accepted into the court's file by the clerk. So there was no filing. That's a central point of disagreement.
Mr. Conley, may I ask you a question? I'm wondering if there is a local Shawnee County rule that says if a document does not comply with every rule, such as page numbers, it shall be rejected. Or is there any discretion with that person in the clerk's office to say, oh, this is good enough?
Your Honor, the answer to your question is I don't know for certain. I haven't reviewed all of the rules. I've reviewed the rules that were immediately apparent to me that they were applicable. There is a rule that sets out the page number requirement. And there is a rule, as I just cited, that says that defines when it's a document is received. So, as I said in response to Judge Atchison's questions, our position is, in response to the question about reasonableness, is that it is reasonable for a court clerk to apply the clerk's rules of that court. So again, that's one of the central issues is, if you look at the district court rule, there was no filing in this case. So this is not a case of an imperfect filing that can later be cured or fixed. It's a case of no filing at all within the jurisdictional window. And it should be noted that there was not even a filing in the additional 30-day window that would be applicable if the excusable neglect exception applied. Now, that doesn't apply in this case. So I want to turn quickly to the merits. But actually, before I do that, I want to respond to some of the discussion regarding Becker and the other cases that were noted by appellant.
Let me ask you a question first. When you look at Rule 23C1, and it says a clerk of the district court is authorized to return the document only for the following reasons. It lists A through D, but they don't list can return for a lack of page number. How do you reconcile that rule?
Your Honor, as this court noted in its response to the show cause issue, that rule does not apply to the Shawnee County District Court. And so in response to the argument that, that should be adopted as policy or some sort of guidance, I think that argument could be persuasive in the absence of a specific local district court rule that's contrary to that. And so when we have by the clear language, the court saying Rule 23 doesn't apply to Shawnee County District Court, and we have a clear Shawnee County District Court rule that allows for a different result, I think that the specific local district court rule should control. And I want to respond to the discussion of Becker. Key differences in Becker. There was a filing in Becker. There was no doubt that there was a filing. Everyone agreed in Becker that the individual had filed the notice of appeal. It was a content issue. It was filed on time. It was accepted. No doubt that there was a filing on time. Down the road, the court then decided to dismiss the case because the court found that the contents were not acceptable because there was not a wet signature. Different case. Again, this is not a case of a filing where there's some problem with the content. This is a case in which the document was not accepted for filing, so there was no filing. Now, in regard to the Lambert case that the appellant has cited, again, as we stated in our brief, and I won't repeat our brief, but the court didn't reach the issue there. That was a summary judgment issue. It was an issue of whether there was even a material fact that had been raised about whether the filing deadline had been met. And the court found there was no issue of material fact as to whether the filing deadline had been met. And it applied, some rules and some inferences that apply in the summary judgment rule context that don't apply here. And as Judge Gardner noted, there is also some important differences in applying statutes of limitation to specific statutes that grant this court with jurisdiction. So I won't belabor that, but quickly moving to the merits. Even if this court were to review the merits of this case, the outcome of this appeal does not change. Frankly, if this court gets to the merits of this appeal, this becomes a much more straightforward and easier case. Because as 3 tribunals have already found, Dr. Myers fell far short of his heavy burden to prove by clear and convincing evidence that he is sufficiently rehabilitated to be allowed the privilege of practicing medicine on the residents of this state. And in this context, on the merits, the number 3 is very important. As I noted, 3 tribunals have reviewed this. First, the ALJ. Second, the 15-member board of Kansas State Board of Healing Arts, 12 of whom are practicing licensed healthcare practitioners in Kansas, several of whom are surgeons themselves. That's the second tribunal that reviewed this after the ALJ, did a de novo review of the record. And then after those 2 occurred, there was an appeal to the district court. And Judge Watson in the district court reviewed the entire record independently as well and came to the same conclusions. And if you read the opinions, came to those conclusions quite easily that in this case, appellant has just simply not met what is a fairly heavy burden. Now, the second 3 that's important is that there's been at least 3 multidisciplinary professional assessments of Dr. Myers that have been conducted over more than 10 years. Each of those multidisciplinary assessments identified very serious problems with professionalism and concerns in regard to the safety of this person to be able to practice. Each of them provided recommendations to the appellant on what he should do to rehabilitate himself. And appellant has not been able to fully comply with any of those 3 sets of recommendations.
Mr. Poling, could you remind me when the last of those professional assessments was done?
In June of 2013, Your Honor. And that was the PRC assessment. You know, I'll note for the court that I think the most important portions of the record for the court to review are the 2 PRC reports that are in volume 2 at pages 390 through 412. Provides a very, fairly comprehensive view of the history and what the consistent issues are in regard to professionalism. That was the last assessment. Now, it's important to note that these multidisciplinary professional assessments, it's not just one person giving one provider's opinion. It's a team of experts who are well accustomed to doing this, to looking in depth at a person's issues in regard to professionalism, making assessments, making recommendations. It's not just as the appellant is asserting in support of his case, that it's one provider, in the appellant's case, one therapist who he was referred to by his attorney.
But what is your response to counsel's assertion? This is all old information.
Well, as directed in the Backus factors, that's an essential element, is to look at the history. And chronicity is very important in this case. That's noted in the PRC report. This person from 2005 and 2006, when he first has the Rush assessment, through 2013, has very consistent issues. And the PRC assessment noted that those consistencies and the chronicity of his problems, failure to really take ownership and failure to truly commit to rehabilitation. So you compare that chronicity to what appellant has tried to assert to support his very heavy burden, which is, well, I've gone to one therapist who my attorney referred me to, who referred me to one psychiatrist who saw me for 2 hours. And that therapist, Dr. Keenan, thinks I'm okay. I don't want to do an assessment that's been recommended by PRC. I don't want to do what I said I would do in the 2011 consent order, which is to follow these recommendations and get these assessments. I want to just rely on that one Dr. Keenan's opinion.
Did the board have the authority in the process of hearing this to require Dr. Myers to undergo what would be the equivalent of an independent medical or psychological exam? I mean, is there authority like that? I mean, equivalent to what's in the rules of procedure for an independent evaluation?
Yes, there is authority for that, Your Honor.
They didn't do that in this case.
Didn't do that in this case, but again, the burden is on the appellant under 652844 to show that he is rehabilitated.
Well, and he presented someone who was an expert, I mean, by training at least, who said that. And as Judge Gardner pointed out, what is in the record in terms of evaluation of Dr. Myers on the other side is an assessment from 2013 of here's what's wrong with you. The board can do what it chooses to do, but there isn't, in that sense, a countervailing expert opinion that says at the time of the hearing, he's not qualified or he's not able to do this, right?
Your Honor, the way I would respond to that is that, again, returning to the burden of proof, with respect, we believe that would flip the burden of proof by saying the board has to come forward with positive evidence. Where we have a case where we have a very clear and well-documented history of very thorough assessments, the only thorough assessments in the records all consistently say that this person, is not rehabilitated, has serious problems that need serious assessment and a structured approach. That's in the record. Those are the only, multidisciplinary assessments in the record. And now the burden is on the appellant, the licensee, to show by clear and convincing evidence that he is sufficiently rehabilitated to practice medicine in this state. So, given the long-standing issues, the consistency of those issues, the chronicity of those issues, the position of the board is you needed to do more than just go to one therapist to whom you were referred by your attorney who will say, well, you're okay. That's our position. And the third three I wanted to mention is 3 months. So this is not the end of the road for Dr. Myers. If this court dismisses the appeal under 652844, the licensee can reapply for reinstatement 3 years after he's rejected, which in this case may be as early as November of 2020, November of this year. So he will have the opportunity to come back to the Board of Healing Arts and say, here's what I've done over the 3 years. I can show you by clear and convincing evidence, I am now fully rehabilitated. So this is not the end of the road for Dr. Myers, but as the legislature has made clear, the guiding principle of the Board of Healing Arts is public protection.
So if he comes back in November and applies, are you going to take the same position that the assessment that was done 7 years ago is good enough given the burden? I mean, he can never win that game.
Your Honor, I would disagree. He can win. He can win by following the recommendations that were in the 3 prior assessments. In the 2013 assessment, it was recommended that he, when he's ready to start, because they found he's not even ready to start. When he's ready to start, he needs to go back and do another full assessment somewhere to get a multidisciplinary approach and determine what he needs and show, look, I know I didn't comply with the 2011 order. I've gone back and I've gone to each of those requirements and I've complied. That's one thing he could do. He could do a lot of things. And as you noted, I think correctly, this is more of a totality of the circumstances type of review. So, he will have the opportunity to show, through the passage of time and what he's done, that things have changed for him. But given a long history, this is not one incident 10 years ago. This is a long history, of multiple teams of professionals saying this person has fundamental problems in terms of one of the core competencies, according to the ACGME.
Let me ask you, I mean, one of the VACA factors is morality or good moral character. How is he supposed to demonstrate that? I mean, how does one do that? I mean, I was thinking about, how do I prove that I'm a good person? Well, how do you prove that you're a good person?
there's many ways to do it. You know, I don't think that there is a laundry list of ways to do it.
Well, I'm
think,
just asking you. I mean, what are the criteria for doing that? I mean, how do you do that? You tithe to your church? I mean, does that qualify? I don't know. What?
I think engagement, in positive, wholesome engagement in your community, as you just noted, could be one factor. As the board noted in the final order, you know, there are some things that Dr. Myers has started doing right, it appears. The board did not discount that he's gone to a therapist, that he's seeing Dr. Keenan. The board specifically noted that's a positive step. You know, there was other positive steps that were noted by opposing counsel. We're not saying he hasn't made positive steps, and there are a lot of ways you can say, hey, I've taken responsibility and here's what I've done. You know, a key thing to do is say, I've taken responsibility. And to me, the first thing you would do if you failed to meet the consent order requirements, you ended up getting your license surrendered because you weren't able to meet those requirements and follow the recommendations, is go back and follow those recommendations. Get a thorough assessment and follow those recommendations to the T. Don't just say, I'm only going to accept going to this one therapist that my attorney has sent me to.
Excuse me, Mr. Poling, I'll let you go over. I'll give you 2 minutes to wrap up.
Thank you, Your Honor. I want to respond to just a couple items quickly. The aspersions that were cast on the ALJ, I disagree with those. I don't think they have merit, but I don't think they're relevant because, again, 2 other tribunals have come to the same conclusions, and there's no allegation of bias to the other tribunals. And, you know, Mr. Stafford said he's had an aha moment. Again, if he's truly had an aha moment, he would go back and do what the board and the KMS MAP program has been telling him to do all along, and he hasn't done it. And again, if you look at the chronicity in this case, you have an issue where if you look at what he's done and the chronicity and consistency of the problems that he has had in terms of professionalism and compare that to the very isolated, limited steps he's taken to address those, he simply hasn't met what is a very weighty burden and what is a vital burden to the public safety of this state. Thank you.
Thank you. Mr. Stafford, you still have 4 minutes for your rebuttal.
You done? Unmute yourself.
Oh.
There you go.
Thank you. Mr. Poling referred to 3 tribunals that have gone through this. Only one person, and that was the initial hearing officer, actually heard the testimony. The 2 other tribunals were simply record reviews. And to say that, you know, this has gone through 3 tribunals to hear the evidence, I think would be a huge stretch. They've looked at the records. In appearing before the board on a review of the final order, even at that point, when Dr. Myers was before the full board, they didn't have questions of him. They gave no testimony. They heard arguments of counsel, but they didn't go anywhere beyond that. I want to talk about the multidisciplinary assessments and their recommendations. Now, the early recommendations were for treatment. The final recommendation on June 13th by PRC did not recommend or require his return for another assessment. As I understand that report, they said, if you get treatment and you want us to reassess, we'll do that. If there had been a hard and fast recommendation that he get another multidisciplinary assessment, he would have done it. I also want to mentioned the threes with regard to Dr. Keenan, and the 3 times it was pointed out that I referred Dr. Myers to Dr. Keenan. I referred Dr. Myers to Dr. Keenan for treatment, not for expert testimony. I referred him to Dr. Keenan because of her abilities and her experience. She also referred Dr. Myers to Dr. Hale, who is a psychiatrist, to see if there is a magic pill that would be necessary to treat Dr. Myers. And his conclusion was, no, there isn't. Dr. Hale was called as a witness by the board at the hearing, and he was actually pretty supportive of Dr. Myers. Dr. Keenan was also one of the treating providers that PRC had recommended when Dr. Myers exited. This is in the testimony. As he was exiting, they suggested he get treatment by a psychologist, and they gave 3 doctors' names, one of which was Dr. Keenan, who at times has worked with PRC. So based on my recommendation and based on PRC's recommendation, that's where Dr. Myers went. I don't believe that anywhere the board's evidence said that Dr. Myers was not rehabilitated. They didn't have any information to make that sort of assertion. We had undisputed testimony of what Dr. Myers had done and how he had learned, had grown, had rehabilitated. And we asked that this court then remand this case to the board with instructions and the opportunity for Dr. Myers to once again practice his profession. So thank you for your patience today, and if you have additional questions, I'll be glad to answer.
Thank you, Mr. Stafford, and thank you, Mr. Poling. We appreciate both your arguments, and we'll take this case under advisement and get you opinion, written opinion, as soon as we can. We want you both to have a good day. Thank you very much.
You also. Goodbye.
Bye.